According to Sir Thomas Powell Buxton, experience shows that success is due less to ability than to zeal. The winner is he who gives himself his work, body and soul. Hello and welcome. This is The Eagle, Nigeria's foremost anti-corruption program. My name is Kamilu Gebi, and presenting with me is
Kei Folarin. Hello viewers and welcome to the program. We begin today with a report on the leave granted the EFCC by an Abuja High Court to prosecute former FCT Minister Malam Nasir El-Rufai and 2 others on a newly amended charge. This and more shortly.
A High Court of the Federal Capital Territory in Abuja has granted the Economic and Financial Crimes Commission leave to prosecute former Minister of the Federal Capital Territory Malam Nasir El-Rufai and 2 others on a newly amended 8-count charge. The 2 other accused persons are former Director General, Abuja Geographic Information System, Aegis, Altine Jibrin, and former General Manager, Aegis, Ismail Iru. They had, in the last adjourned date, through their counsel, Akin Olujimi, SAN, and Kanu Agabi, SAN, opposed their arraignment on the ground that the charge in which they are brought to court was predicated upon a law that was null and void and therefore lacked merit. They also went ahead to question the jurisdiction of the court to entertain the matter, saying that the ICPC Act 2000, under which the accused persons were charged, had been repealed and could therefore not be used as a legal platform for their trial. They also argued that the EFCC lacked the power to prosecute them as the entire allegation against them did not constitute financial crimes. In his response, counsel to the EFCC, Adebayo Adelodun, SAN, submitted that El-Rufai and the other accused persons are newly brought before the court on the basis of an 8th amended charge and urged the court to allow their immediate arraignment. He pointed out that, as a matter of law and fact, the objection on this ground has become mute, spent and academic by reason that the prosecution has filed an amended charge. He vehemently opposed the plank upon which the defense counsel based their objection to the arraignment, saying that the objection was doomed since it was based on an unreported decision of a court of appeal that had been voided by the Supreme Court. Also, the prosecution counsel said that the offenses the accused persons were charged are known to written laws, stressing that it is not correct to say they were charged under a non-existing law. Ruling on the consolidated motions to amend the charges and arraign the accused persons with that of preliminary objections by the defense counsel, Justice Abubakar Sadiq concurred with all the positions canvassed by the prosecution and ruled that the judgment against the ICPC Act 2000, on which the defense based their main argument to oppose their trial, has been voided. He ruled that the ICPC Act 2000 is a valid, subsistent, and alive legislation which has not been invalidated. I have not come across any judgment or any act of the National Assembly that repealed or voided the Act. He further disagreed with defense counsel on their argument that where a law is pronounced void without revalidation, it ceases to have effect and therefore it is incurably bad. He ruled that owing to the present situation and in accordance with Section 208, subsection 1 of the Criminal Procedure Code, the court has a discretion to alter, add to, or frame a new charge by way of amendment any time before judgment is delivered. Justice Sadiq in addition said, vital consideration which governs the amendment of a charge, whether to grant the leave to amend the charge or not before ruling, is that such may be made without injustice to the accused persons, and in this case, the accused persons are yet to take their plea, so I cannot see how a miscarriage of justice is occasioned in this instance. As to whether the EFCC has the power to initiate the prosecution of the accused persons, the judge concurred with the prosecution that EFCC's mandate is elastic. He stressed that both EFCC and ICPC are organs of government and that EFCC is prosecuting the case on behalf of the Attorney General of the Federation and the Federal Republic of Nigeria. He equally said that Section 6, subsection B and C not only empowers the Commission to investigate a whole gamut of criminal activities, but that the inclusion of the word etc. and include in Section 46 means an extension of crimes not mentioned therein and is intended to construe other crimes not intricately mentioned. He thereafter granted leave to EFCC to prosecute the accused persons and ordered their counsel to produce them in court at the next adjourned date for arraignment.
I got a telephone call. Anytime I close my eyes, I see dead people chasing me in my sleep. My Jehovah Magadam. Is it possible for someone to become restless just because of his past? Nevertheless, unless you have killed somebody dead, then the spirit will be haunting you. Was you all contractors? I embezzled all the money for the roads that are now death traps, killing people every day. I approved the supplies of fake drugs. On pipe-on water. I embezzled the money. I dey fear you. You are supposed to fear a special man that we don't people of EFCC. I chose people who are doing work to support other people who need EFCC as well as the accountant of threats to prove the lie. Jail. Anyway, threats are not just about our prayer well. Making money. When other people are didn't die of hunger and neglect. Be careful. EFCC and watch.
EFCC will get you anywhere, anytime.
A High Court of the Federal Capital Territory in Abuja, presided over by Justice Olukayode Adeniyi, has ruled that the exhibit tendered by the Economic and Financial Crimes Commission in the prosecution of a former Director General of the National Gallery of Art, Joe Musa, over a 2.2 billion naira scam is admissible in law and very vital in the suit. At the resumed hearing of the case on Monday, 28 March 2011, the prosecution witness Dr. Achubo Henry Uche, Acting Director of Finance and Accounts in National Gallery of Art, in his testimony told the court that the former DG had in August 2006 made transfers of funds which were allocated in the budget for some projects which were never executed. Prosecution counsel Sir Steve Odiase backed up the argument when he provided 4 documents to the court to be tendered as evidence. The documents include a financial statement from an external auditor, Ambrose Ekmefua and Co., Chartered Accountant, a management ledger 2007, budget containing income and expenditure of the NGA from Budget Office of the Federation, and a list of programs that were not executed as appropriated in the 2008 budget. The defense counsel raised objection to all the 4 documents tendered as evidence by the prosecution, which was overruled by the judge and subsequently admitted as Exhibit P1, P2, P3, and P4. The second prosecution witness, Ibrahim Galadima, took the stand and also tendered letters written by EFCC to First Bank and Spring Bank on the activities of the former DG and the responses which were also admitted as evidence. Defense counsel thereafter entered an oral notice submission on which they will submit written addresses to the court. The court has adjourned to May 6, 2011 for adoption of responses. It will be recalled that the court at the last hearing granted leave to the Commission to file additional proof of evidence. The additional proof of evidence granted EFCC by Justice Adeniyi is a management letter on the financial statement of the gallery for the year ended December 31st, 2008 by a firm of chartered accountants. The audit report revealed that some accounts were debited with various sums of money which were lumped together and not properly analyzed or easily matched with specific payment vouchers. Also, too many accounts or transactions were grouped and posted as one account head without sufficient details. The audit report further stated that staff advances on the ledger of the gallery neither followed observations nor implemented the recommendations in previous year's report. The report also showed that lapses noticeable in 2007 audit still existed in 2008